what I wanted to do really was divide my talk into two parts. First bit will be really talking about the preliminary reference procedure generally and its importance for the development of the case law and for developing the, as it were, the dialogue between the Court of Justice and the judges who have to apply the regulation on the ground, namely the judges before national courts. And I want, obviously, I'm not an official spokesman for the Commission, so please don't go away and say the Commission's official position is this. I'm not a spokesman for the Commission. I'm just really sharing my own experiences as someone who has pleaded quite a lot of preliminary references. Still less, of course, am I a spokesman for the court. So I'm simply giving my own experience and thoughts on the matter. As you know, the preliminary reference procedure is really of vital importance for developing EU law. All of the basic principles of EU law, such as direct effect and supremacy of EU law, have been actually laid down in the preliminary reference procedure. And so far as the Brussels regulation goes, we have here an instrument which is the successor of a convention which entered into force in 1973. So you would kind of have expected that all of the practical questions would have been worked out by now. In fact, that's far from the case. And in particular, since the entry into force of the Lisbon Treaty, which for the first time allowed courts of first instance to make references for a preliminary ruling to the court on the Brussels regulation, there's been a kind of explosion of cases. I think there must be something like 15 to 20 cases a year on the interpretation of the Brussels regulation. And when you think that the court only gets something like 500 references a year, so quite a large percentage are actually on the Brussels I regulation. And of course, sometimes what the court decides on the Brussels I regulation can have an impact equally on the other instruments of civil law. As you know also, the judges of courts of first instance and courts of appeal may but need not make a reference to the Court of Justice in Luxembourg if they're faced with a problem of either interpretation or an issue of the validity of an instrument. There's been no challenges to the validity of the Brussels regulation, either Regulation 44/2001, and I don't see any reason why there would be any challenge to Regulation 1215 of 2012. There have not, of course, yet been any judgments on the recast regulation, but the court has always taken the approach that once the convention was turned into the regulation, when the regulation changes, the pre-existing case law continues to be valid, and which is logical, unless, of course, a particular provision has changed. So, obviously, we have nothing yet on the big change of the regulation, namely the new procedure of enforcement, the abolition of the exequatur. But since a lot of the regulation has remained untouched, the case law still holds true. As I think the authority of the case law of the European Court is obviously something that's extremely important. I mean, I'm from a legal tradition where judges effectively make the law. So for me, it's second nature to say that if the court has said it, it's right. Some of you may come from kind of different traditions where a judgment is more just an illustration of how the law is applied. And sometimes reading national judgments, I'm sometimes surprised that even national courts seem to attach more weight to the writings of professors than they do to their own judgments. But that's not something you can do. I see my colleagues laughing. I can think of one particular jurisdiction where this is particularly flagrant. Although, of course, courts from that country do provide good references. But you see a whole mass of citations of learned professors. There's, of course, it's something which you can't really do when you're looking at the judgments of the Court of Justice. They make the law. And speaking of the relationship between academics and the courts, I read a German criticism of a particular judgment of the Court of Justice. And one of the criticisms was not so much the reasoning of the court, but the fact that the Court of Justice had ignored the herrschende Meinung, the prevailing opinion. In other words, the particular commentator didn't like the judgment because the court hadn't followed what he or she had said. Needless to say, this wasn't necessarily the herrschende Meinung in every member state, but this to me seems odd. You may not like what the court has said, but it's there, and it's very unlikely that the court will actually row back from what it's said. So that's the first lesson, I think. Do treat what the court has said with considerable respect, even if you're not convinced by it. Secondly, I think if, as a judge, you are faced with a question of interpretation, you would need to decide whether or not a reference should be made, whether this would be by own motion or more likely because the parties disagreed and asked for a reference to be made. Remember that, except for a court of last instance, there's no obligation to make a reference. On the other hand, if the point is really open, then it may be better to make the reference and to get an answer. But you have to sort of, I think, steer between the Scylla of going ahead and maybe getting it wrong if you don't ask for a reference, and the Charybdis of asking a question which is a bit too obvious, really. If a question is asked, the court will do its best to answer it. It's very rare for the court to refuse to answer a question sent by a national court. In practice, it will only do so either if the question is too hypothetical or if it appears that there's not really a dispute between the parties. That's obviously extremely rare. And the other situation is if the question is so incomprehensible that the judges can't answer it. Clearly, they're reluctant to do this because the court wants to encourage references to be made and to encourage the dialogue between national courts and the Court of Justice. So they would be very unlikely to say, go away, we're not answering your question, we simply don't understand what it means. But nevertheless, in order to facilitate the task of the court and in order to get an answer that means something, it's very important to provide the Court of Justice with all the elements it needs to analyse the question and give a sensible answer. So in particular, it's important to explain clearly all of the the context of fact and also the context of national law in which this question comes up. So, a kind of a readable order is extremely important. And one thing I've noticed is that sometimes I'm thinking of sometimes orders from the legal tradition which I know best. Sometimes the judge relies a little too much on orders which are agreed by both counsel, will send it off without necessarily without necessarily casting too much of an eye over it to ensure that it actually makes sense. So, and also the court doesn't like judgments or doesn't like orders for reference where there are perhaps 23 questions. The court will inevitably say, well, what the national court means is X, Y, Z, and so kind of telescope this down to probably groups of 4 or 5 questions. If I got to be competing with the workmen, I need a little water. So as I say, I think these are all things to bear in mind if you're actually making references. Remember also that before the Court of Justice, this is simply a kind of an interlocutory question. The court itself will not solve the case. The court will simply answer the question and refer the matter back to the National Court for a final determination on the merits. And the court will itself, of course, also not go behind the facts which the National Court has established. Occasionally we find parties saying, well, that's not true, it's a misstatement. The court will, of course, always say, this is not our business. The question of facts is for the National Court. But remember that when the matter comes before the court, the parties before the National Court, the member states and the Commission can put in written observations and also oral observations if there's a hearing. And if the validity of an act is called into question, then also the Council and Parliament will also put in observations because they're defending the legality of an act. Now, the Commission decided at an early stage, I think back in the 1950s, before most of us were born, that it would always put in observations in a preliminary reference. So systematically in every case, the Commission will have put in written observations and will go to the hearing if there is an oral hearing. So this gives us, I think, a particular responsibility. We have a kind of amicus curiae role, which I think the other parties don't, because they will have a particular interest in a particular decision. So, as I say, that's my preliminary remarks really on kind of tips as to what to do if making a reference. Obviously, if you make a reference and then the answer comes back, in the majority of cases, this will be sufficient. The National Court will be able to pick the bones out of what the Court of Justice has said. It's bound not only by the operative part of the judgment, but also by the reasoning that underlies it. And as I've said before, although strictly speaking, it's only the court that made the reference that's bound by the answer. In practice, what the court says in a reference for preliminary ruling has the status of law, and I can only think of a tiny number of cases where the court has rowed back on what it said in a preliminary reference. So you can't, if you don't like the judgment, you can't assume that the court will reverse it. Sometimes the legislature has reversed what the court has decided, but that again is quite rare. At this stage, I'll perhaps pause and before going on to analyse the case, so I just ask if anybody has any questions on what I've said so far. Nope. Okay. Let's. I don't have a watch, so perhaps. Yeah.
It's 9:30.
Okay, so I've got plenty of time, yeah. Okay, so what I wanted to do now was to look at a few judgments and recent judgments, really, partly because they are important when it comes to the interpretation of the regulation, but also to look a little bit at technique in sending references and how the court deals with them. So what I wanted to look at, which is probably one of the most recent judgments, is a case, the reference is case C-175-15, called Taser International. Now, the judgment is not a particularly important one, but I pick it out partly because I think this is a case where there was probably no need to make the reference at all. It's a situation where the national court should have been able to work out the answer for itself. It's a judgment, it's an order from a Supreme Court. So one can perhaps understand why this court made the reference. It was better to err on the side of caution and make an unnecessary reference rather than to risk not complying with its obligations to make a reference. But nevertheless, I think it's a situation where the result was acte clair. And I think the court also thought this, in that it dealt with the case by means, it did actually give a judgment rather than a reasoned order, but it was a chamber of three judges, which tends to be allocated to the most straightforward of cases, which is quite unusual to have a chamber of three when there's a reference from a Supreme Court. And so it was a chamber of three judges, no Advocate General's opinion and no hearing. So that's almost a way of the court saying, come on, you should have been able to work this out for yourself, boys. As I say, I'm not pointing the finger at the judges from this particular jurisdiction because I can understand why they made the reference. But as I say, I think it was a case really of acte clair. The facts of the case were that with this particular member state, the dispute was between an American party and a company which was domiciled in the member state from which the reference was made. And the parties had concluded a jurisdiction clause conferring jurisdiction on the courts of the United States. Now, this didn't fall, this jurisdiction clause doesn't fall within the regulation anyway. So, in principle, the regulation at this stage was not kind of engaged. A dispute broke out between the parties, and the American party, so who presumably was in favour of the American jurisdiction clause, brought an action in the member state in which the other party was domiciled. So under the basis of Article 2 of the old regulation, now Article 4. So in principle, you would have expected the defendant domiciled in the member state to have been quite pleased about this, and so the defendant didn't contest the jurisdiction at all, just entered an appearance. Now, in this situation, even if the defendant had contested the jurisdiction, it's very debatable whether the national court could have done anything about it. There's nothing in the regulation about being able to stay proceedings in where there is a jurisdiction clause in favour of the courts of a third state. Clearly, if it's a jurisdiction clause in favour of the courts of another member state, there's an obligation to stay proceedings. But there's nothing in the regulation about what to do if there is a jurisdiction clause in favour of the courts of a third state. And I think that probably the correct position is that there is no jurisdiction to stay, there is no discretion to stay proceedings in these circumstances, pending the entry into force of the 2005 Hague Convention on choice of forum. So, in any event, this issue of the American jurisdiction clause was a red herring. The Court of First Instance said that it had jurisdiction, and then somehow the matter meandered up to the Supreme Court, the Court of Cassation, where suddenly all sorts of questions were raised. Now, there was, even if the jurisdiction clause had been in favour of the courts of another member state, there was plenty of case law which said that even if there's a jurisdiction clause in favour of the courts of member state A, but the claimant nevertheless brings proceedings before the courts of member state B, and the defendant enters an appearance, then in principle entering an appearance without contesting the jurisdiction is a matter of tacit prorogation. You're regarded as having accepted the jurisdiction of the court. And there was plenty of case law which said that if you've got a kind of conflict between what was old Article 23 on jurisdiction clauses and Article 24 on tacit prorogation by entering an appearance, then it was Article 24 which prevailed. The idea being that the later unilateral consent to jurisdiction overrides the earlier jurisdiction clause. Now, a fortiori, this should have applied when there was a jurisdiction clause in favour of a third state, and that should have been the end of it. But somehow the National Court got itself in a terrible tangle because it decided that the case law didn't cover the situation before it. This is a bit like saying that you can't solve a mathematical problem because the figures are different in the example you've got to solve than the ones that we've shown to you by in an example. The court should have been able to solve this. And then it also raised another red herring, which was an issue of whether the Court of First Instance should have raised this matter of its own motion, which it hadn't done. So again, these were all questions which really didn't need to be referred, but nevertheless, since it was a Court of Cassation, the court pretty much had to answer the question by a judgment rather than by reasoned order. But as I say, I think the underlying message is you didn't really need to make this reference. And of course, the court confirmed, as one would have expected, that yes, the tacit the appearance without challenging the jurisdiction, that was an end of it. in particular, since the action was brought in the court in which the defendant was domiciled. So there was, in any event, jurisdiction under Article 4. I want to look now at, I've chosen 2 or 3 judgments, quite recent judgments, which are actually more on the substance. And I'll look at what I think is probably the most important of these judgments, which is the judgment of 16th of July 2015, case 681 of 13, and the name of the party, not sure if I can pronounce it, but it's called, I think, Jagger Brans. It's spelled D-I-A-G-E-O, Brans. And the case is on ordre public. So, as you know, one of the limited grounds for refusing to recognize or to enforce a judgment given in another member state is ordre public, public policy. Now, although the exequatur system has been abolished under the new regulation, nevertheless, at the enforcement stage, properly so called, public policy is something which can be raised. So on the substance, the pre-existing case law is, I think, still valid. Now, the other very important provision allowing a judgment or requiring a judgment not to be recognized or enforced is protection of a defendant who doesn't turn up. So in the case of a default judgment. So I'm still have to check the numbering in the new regulation. Under the old regulation, this was Article 34. I think I should be retired before I'd learnt the new numbering, but I'll just check it out for you. Yeah, it's now Article 45. So these points, which were Article 34, 1 and 2, and now it's now Article 45, 1, points A and B. Now, under point B, the protection of a defaulting judgment, of a defaulting defendant, there is various protection to ensure that in the case of a default judgment, the defendant didn't turn up simply because he chose not to. There's obviously a danger, in particular in the case of cross-border service, that the defendant simply didn't receive the notification that there was going to be a hearing. That's a particular danger, and therefore particular provision is made for it to be controlled ex post at the stage of recognition or enforcement. However, this point B contains an explicit requirement that, if it's possible, the defaulting defendant must have exhausted appeals in the member state in which the judgment was made. So, for example, if you have a judgment in France, which is a default judgment, it's then got to be enforced in Germany. And the defendant can raise at the enforcement stage the fact that he didn't receive sufficient notice that there was going to be a hearing. However, he can only do this if he's exhausted any local remedies there might be. Now, I mention this because, although it's not directly relevant to this Jagger Brans case, because the ordre public defence does not require explicitly that the defendant, the judgment debtor, have exhausted local remedies. Nevertheless, the this particular defence at the stage of enforcement is used mainly to deal with procedural public policy. In other words, situations where there's been a breach of the rights of defence, but nevertheless it's not a default judgment and therefore doesn't fall fair and square within point B. Now, in this Jagger Brans case, the public policy was raised in quite an interesting way. What had happened was that a company had, in Bulgaria, it had asked for a consignment. I think it was whiskey or something like that, but it was, it's not, it had asked for a consignment of, yeah, it was whiskey, to be seized because the company maintained that these bottles of whiskey infringed its trademark, I think, so some intellectual property right. They then, the national court in Bulgaria originally seized the bottles on an ex parte motion, but then lifted this. Then there was an action brought for infringement on the merits in Bulgaria, and it was dismissed. The Bulgarian defendant, so the company whose bottles had been seized, then brought an action against Jagger Brans, which was domiciled in the Netherlands. So the Bulgarian company, which had been the defendant in Bulgaria, brought an action in the Netherlands for damages flowing from the seizure of the whiskey bottles. And in the course of this action in the Netherlands, there was a question of the extent to which the judgment in Bulgaria dismissing the action for infringement had to be recognized. So there was no question of enforcement. It was simply a question of recognition as a collateral question of the Bulgarian judgment dismissing the infringement action, which doesn't require any procedure. The argument raised by what was now the defendant, the Dutch party in the Netherlands, was that the Bulgarian judgment shouldn't be recognized for reasons of public policy. And they put forward two basic arguments. First, they said that the Bulgarian court had made such a horrendous misapplication of European law that it would be contrary to European public policy to recognize the judgment in the Netherlands. And secondly, the argument was that the Bulgarian courts should have made a reference on this point to the court in Luxembourg. So you can see here how, even at the stage of recognition, the argument that there was a failure by the originating court to make a reference on a point that was not acte claire would be sufficient grounds for refusing to recognize the judgment. Now, on the first point, the court, I think, was partly influenced by its view that in any event it was far from clear that the Bulgarian court had misapplied European law. But it then goes on to say that even if there had been a misapplication of European law, this would not suffice as a ground of public policy to refuse to recognize the judgment. And this is consistent with its earlier case law, where the court has said, well, simple misapplication of national law isn't a sufficient ground of public policy to refuse to recognize the judgment. therefore, by parity of reasoning, nor is a misapplication of EU law. But the court nevertheless adds a kind of rider. It says that misapplication of EU law cannot justify the judgment not being recognised in another member state unless the error constitutes a breach of an essential rule of law in the EU legal order and therefore in the legal order of the member states. It's a kind of rather Delphic remark because the court doesn't give a great deal of indication as to what it would regard as a breach of an essential rule of law. Perhaps a misapplication of the EU competition rules, for which the court seems to have a particular mania. That might be something which is regarded as a breach of an essential rule of law, but apparently not a breach of Directive 89/104, which is on national trademarks. So that part of the judgment is, I think, consistent with the earlier case law. The second part of the judgment, as to whether the judgment of the Bulgarian court could be not recognised because the Bulgarian courts on a matter that was not acte claire had not made a reference to Luxembourg. Here the court was able to deal with this point, dispose of the point quite easily, because the matter had not gone up to the court of last instance. It had been dealt with by lower courts, who had, of course, the option to make a reference to Luxembourg, but didn't have the obligation. So the court here said, well, no, there hasn't been any breach of the duty to make a reference to Luxembourg because the matter didn't go up to the Supreme Court. So that could easily be disposed of. And then very closely linked to that question was also the point that the Dutch party in Bulgaria had not exhausted local remedies. So here the court kind of reads into this point A, the public policy point, not a strict condition, but nevertheless an element which has to be taken into account in the public policy assessment. The fact that the defendant in the originating state didn't pursue remedies up to the Supreme Court meant that his argument for invoking public policy in the requested state was much less strong. So I think the case is a quite orthodox application of existing principles, but it's nevertheless, I think, useful because it articulates some points which were implicit in earlier case law, but which hadn't been made so explicit. But I think there, because the underlying message is, that if the national court in Bulgaria, if the matter had gone up to the Supreme Court, then and if the matter was not acte claire and the Supreme Court hadn't made a reference to Luxembourg, then this might have been ordre public ground for not recognising the judgment in other member states. So it comes back to what I was saying earlier, is it's certainly for a Supreme Court, it's perhaps better to err on the side of caution, because not only is there the sort of nominal fact that you may be breaching your obligation under EU law, but this may in fact either give rise to liability on the part of the state, or it may prevent judgment being enforced at a later stage. How will we for time?
10 minutes maximum.
Okay, yeah, that'll be fine. Thank you. Yeah, just a couple of other cases I wanted to look at very briefly. They're just more routine cases, but I think they're quite useful in terms of what they lay down, and they're also quite recent judgments. Somehow all of these recent judgments are either from Belgium or the Netherlands, so they're Dutch language cases. There's one is from September 2015, case 4714. It's called Halterman, so case 4714. And this was a case on the special jurisdictional regime in the Brussels regulation for the protection of employees. And what happened here was that there was a dispute between a company and a person who had the quality of both director stroke manager and also as employee of the company. So he was both an employee and also a director, which is a kind of status which is certainly under the applicable laws not equated to being that of an employee. The company was quite careful to, in the actions that it was bringing against the defendant, to restrict the claims to breach of the duty as a manager stroke director, and excluded any claims in respect of liability as a simple employee. And the question was that in this situation, where the person is both an employee and a director, but claims are only brought against him as director, is the special jurisdictional regime for the protection of employees applicable or not? Now, I think there were here two possible ways of looking at it. One way was to say, well, if the person is both an employee and director, he doesn't stop being an employee simply because he's sued as director. Therefore, the special jurisdictional provision protecting employees applies. And this was, in fact, the position which English courts had taken in a similar case. The other possibility was to say that, okay, if you're careful to restrict your claims to breach of duty as a director as opposed to as an employee, then you can use the normal rules of jurisdiction, which would include the forum contractus, the place where the employee performed his duty. The court, however, comes up with an intermediate solution, which I think is kind of difficult to apply by national courts, because the court says, well, even if the person is sued as a manager stroke director, this does not automatically preclude reliance by him on the employee protection rules, that the national court has to look at the actual, not merely the formal quality of the relationship, but what it implies in practice. So is this a director who has a lot of autonomy as a shareholder? So, maybe he basically controls things himself. Or was he in practice in a sort of relationship of subordination to the company? It's a bit of a professorial solution, I think, and quite difficult to apply by national courts, because at the stage of determining jurisdiction, the national court wants to be able to do this quickly as a preliminary issue without needing to go into the facts of the case. And here, of course, that's precisely what it's got to do, as a kind of operation which you would only expect at a later stage once jurisdiction has been determined. So although you can see the theoretical attraction of the solution, I think it's nevertheless a solution which is difficult to apply in practice. And then finally, just a very brief mention of another case. which I think is not relevant in every member state. Here it's a judgment from October of 2015, case 523 of 14, which concerns a question of lis pendens and when a court is deemed to be seized of a civil action. And here what had happened was that parties had in Belgium they'd lodged with juge d'instruction, so an investigating judge, they lodged a complaint under the Code of Criminal Procedure, but they also sought to join a civil action to the criminal procedure. Now, this, of course, is a procedure which is known in some member states, but not in every member state. And of course, this is quite a preliminary stage. You can't be sure that the investigating magistrate will find that there is a case, but nevertheless, if there is, then under national procedural law, this was the equivalent to actually issuing a writ, say, against the defendants. And here the court held that, yes, since any judgment given in this type of case would be capable of recognition, that the simple fact of joining themselves as a civil party to these criminal proceedings was sufficient to be treated as seizing the civil court, and thereby would trigger off lis pendens if a similar action was brought in another member state. As I say, I think it's the case is a bit marginal, but I think the court came to the right conclusion in this case. So anyway, that concludes what I had to say. I thank you for your attention, and hope that it was useful.